Welcome to Consider This, the popular podcast series brought to you by the Organization of Legal Professionals. I'm your host, Bridget Novak. This series will focus on the legal industry, current trends, substantive issues, and career perspectives. Each program will run approximately 15 minutes. We hope you stay tuned for this program and join us for others in the future.
Hello, and welcome to part one of a special two-part series on the question, can e-discovery violate due process? I'm Ron Friedman, the moderator for this program. I'm a consultant with Friedman Company, and I blog at Strategic Legal Technology, where I've been covering e-discovery and litigation support for 10 years. My guests today are John Beisner and Rich Bernardo, respectively a partner and counsel at Skadden Arps in Washington, D.C. and New York City. So thank you both for joining the call today. And why don't you just say your names and introductions so the audience recognize your voice?
This is John Beisner.
And this is Rich Bernardo.
Great, thanks. So in June of this year, you co-wrote a two-part article in Law Technology News, Can E-Discovery Violate Due Process? Part one covered proposed changes to the Federal Rules of Civil Procedure, and Part two covered the constitutional due process arguments. I hadn't seen these arguments advanced previously, so I thought it'd be interesting to hear from you to learn more about your thinking.
Well, I think where we got started thinking about this possibility was in frankly just trying to figure out why there was in the document and information production process a default presumption that the producing party would pay for it. And I think the problem was, and the problem continues to be, that back in 1937 or so, when the current version of the Federal Rules of Civil Procedure were first adopted, it was a very different world. And when you came to the production of documentary and physical object evidence of various sorts, you'd make your request, and the attorney for the responding party would call you up and say, "Hey, Joe, I got the stuff together, and it's here in my conference room, and why don't you come over and take a look at it?" And counsel who had requested the material would go and look through the material, and of course you didn't even have copying equipment in those days, so the requesting party would basically say, well, certain parts of this look relevant, so make sure you hang on to it, and they'd have a cup of coffee, and that would sort of be the end of the document production process. But other than a cup of coffee, there was really no expense involved in that other than getting the documents to the location for inspection. And so I think when the framers of the current system were looking at that, it was a very different world. You didn't have the enormous costs of gathering what in those days was basically documents, carbon copies of various things that might be in somebody's file drawer, and there probably wasn't a whole lot to think about in terms of cost. And of course, with the development of ways of storing information and the evolution towards the e-discovery process, that whole situation has changed. And so it was really just kind of thinking about what was the origin of this notion that a court didn't have to stop and think about who ought to pay for whatever costs are incurred by the party that has to respond to these requests in gathering and physically producing information.
Well, and to follow John's point, when you go back so far as 1937, and then with the advent of copiers, in addition to the cup of coffee, frequently the requesting party would have material shipped off and would pay himself for the copies and for the copy costs. And somehow over time, the receiving party's payment of it has sort of shifted to the producing party, and it's largely because, as John says, of the advent of electronic storage and who has the information and how it's being produced. So this idea is actually not so far-fetched from where the rules originally were.
Okay, so that's interesting. And let me quote to kind of drive home the legal argument. Let me just do a short quote for the audience from the article and ask a question. So you wrote that forcing a defendant to pay significant discovery expenses without any contribution from the plaintiff, absent any finding of liability, arguably infringes the defendant's right to due process. So that's a constitutional argument, which in the article you do acknowledge is novel. So you've explained the shift from where we were historically. What's the constitutional argument that this may violate due process, that we've had that shift?
Well, in a nutshell, the argument is as follows, and that is that it requires the responding party, in essence, to pay money to the party that has requested the information without any finding of liability. It would be the same as if you said, well, I've sued you, and so you have to pay for the cost of my attorney merely because I've sued you. Or you have to give me a down payment on the judgment that I'm asking for just because I've sued you. And it's, from a constitutional standpoint, you shouldn't be obliged to pay the other side until there's been some finding of liability. You may be required in some instances to preserve assets or whatnot in certain circumstances to ensure that justice can be done, but to actually have to turn over cash, which is in essence what you're being obliged to do here, because in some of these cases to comply with the document requests that are being made, the Rule 34 requests, costs millions of dollars. And that's really the nub of the due process argument here.
Right, and you in the article, without doing too deep a dive into the legal arguments, you do cite two cases, one having to do with a home and the other with, I believe it was cash. How strongly do you think those apply? I mean, I understand the principles of don't take property until there's been a finding of liability. Do you think do you want to talk briefly about the two cases?
Well, I think they support. I mean, obviously those are in different circumstances, but I do think that it's a hallmark of our legal system that there is no presumption of liability, and therefore no presumption that as an accused party in a civil lawsuit that you have to pay money to the other side until there has been a finding of liability. And so I think that's really the nub of it, and I think that those cases support the general proposition. Although I would acknowledge, as we did in the article, this is somewhat new terrain. I mean, and let me make clear. I mean, I think that if you're in a lawsuit where both sides are providing each other with certain amounts of discovery, I think it would be, I will acknowledge, probably harder to make that due process argument. I think what we're really focusing on are cases where the discovery is very one-sided, and one party, usually the defendant, is being asked to provide enormous amounts of information without any comparable flow of information coming from the other side.
Well, I think the time is ripe to address it, and I think the discovery context is a particularly good one in which to apply it, because, as John mentioned earlier, the costs of discovery are staggering today. There are some statistics we provided in the article, but I think we've all read that as information continues to be created, it grows in leaps and bounds on an annual basis. And I think as you look ahead, the amount of discovery and the cost of those discovery are going to continue to rise. So we're talking about a constantly increasing cost that's already very, very high.
Right, although the law student in me, and I am not a practicing lawyer, but the law student in me struggles with the continuum, so sort of at what point does the burden become so high? And there are some rules that we'll get to that discussion in a minute, but just to pursue the due process, I guess I'd raise two questions to you. Is it a matter of at what point do you cross the line? So there was some cost that was acceptable and now it's not, and then how do we distinguish between discovery, which clearly costs defendants, and as you say, it's typically large corporations being sued by plaintiffs, lawyers, is I think the case we're talking about. But there are a lot of other lawsuits where even if you don't have a lot of discovery, you have to fork over money to a lawyer to defend yourself, even if it's a baseless claim. So how do you constitutionally make those distinctions?
Yeah, I think there's a difference there. I mean, we do not, admittedly, have a loser pays system, and so I think that the idea that you have to hire a lawyer to defend yourself if you're sued, and you may end up having to pay for that. I think that's a very different circumstance, because that's defending yourself. Here we're talking about the requesting party wanting information and wanting substantial effort to be undertaken in order to obtain that information. And I think that puts it in a very different category of basically saying, I want a lot of information from you and I want it for free. And that's where I think the due process line is crossed. I mean, I think as a technical matter, the due process line is probably crossed at the point at which I'm having to give more than I receive. I just think as a practical matter in a lawsuit, though, this argument becomes substantially stronger so as to give rise to a constitutional issue if the disparity has become quite large.
Well, and I think another factor here is that unlike your defense where, a company or client can choose, one quality or cost of legal representation for another, the costs of discovery are very objective. They're very quantifiable, and it's something that you can get your arms around in terms of saying, here, this is something that both parties are getting benefit of or burden for. So I think it's very different from your legal costs where you can choose to have yourself represented in a variety of ways. Here's something where, it's going to cost X amount of money to produce X amount of documents, and that really doesn't change at the choice of the parties.
Well, that's an interesting analysis. Do you think, if you look at constitutional law writ large, there is often line drawing. So do you think this is a line drawing exercise or is it more of an absolute?
Well, I think that it probably is more of a line-drawing exercise, and frankly, I think what the objective that we have in raising this whole issue is really a challenge to the presumption that the responding party has to pay for the discovery. I mean, look, let's step back from the constitutional issues and look at what we're really talking about here. I'm firmly of the view that in many cases, discovery is not being used to obtain information that is needed for the litigation. Discovery is being used solely to create leverage, to create costs that will force the responding party to think seriously about settlement. There are many cases that get settled not because they're meritorious, but because the defendant concludes that it's simply not worth the cost of the discovery that will be generated to defend the lawsuit. So they just take the money that's likely to get spent on discovery, bundle it up, and offer it as a settlement. And that is really what we're getting at here. And further, I think if there is a question that is out there about who pays for it, if you eliminate the default, I think the requesting party on both sides is going to think a lot harder about what discovery is really needed. There's going to be, some discrimination between what's needed and what isn't needed. The system as it is right now basically says to the requesting party, here's the candy store, kids, and you can have anything you want and everything in the store absolutely free.
Well, that's a great point.
And what self-respecting kid isn't going to say, I'll take it all?
Well, as an undergraduate economist, I do think in those terms, and free goods definitely are overused. So I think that's great. Now, do you think if we pull back a little bit from the Constitution, we talk about some of the practicalities of litigation and discovery, there are pending rule changes to the federal rules of civil procedure. So the advisory committee on those rules is considering e-discovery rule changes. Might those address these concerns and remedy the constitutional defects as you see them?
You know, the proposed amendments to the rule are certainly welcomed, and I think they go a long way to embed concepts of proportionality into the rules in a way that they haven't been done before. But they really don't go far enough because absent focusing on costs, whether either through some presumptive each party pays their own share and it gets adjusted later, or some factors that the court is required to take into account, the dialogue on costs is not likely to happen until the producing party puts it in some motion, and usually that's at the end, and usually it's considered by the court, but rarely, in my experience, except in unusual circumstances, granted. So I think the rules, while they're making valiant efforts to try and address a number of these issues, certainly don't go far enough with respect to costs, and there's still an underlying presumption of, you know, the kid in the candy store that they get it for free.
Thank you, John. Again, my guests today have been John Beisner, a partner in Skadden Arps' D.C. office, and Rich Bernardo, a counsel in Skadden's New York office. We will continue our discussion on the vagaries of e-discovery and whether it violates due process in Part 2 of this program. I hope you're able to join us.